The Economic and Financial Crimes Commission has denied disobeying a court order in its bid to arrest and arraign former Kogi State Governor Yahaya Bello over the 80 billion naira money laundering charges pending against him. Acting Director of EFCC's Public Affairs, Wilson Wujarin, responding to allegations of violating a court order concerning Bello, explained in a statement on Monday that the order of the Kogi State High Court in Lokoja obtained by the former governor to shield him from arrest has no relevance to the criminal charges against him. He said Bello sought refuge in a fundamental right enforcement action through an order granted by Justice Isa Jamil Abdullahi of the Kogi State High Court. The order did not vitiate or nullify an order made by the Federal High Court for the arrest of the former governor for the purpose of his arraignment. End of quote. Well, Daniel Bwala, a lawyer who appeared on the morning show yesterday, stated that court orders must be respected and obeyed by the EFCC.
Based on what transpired in court, there are two facts to be gleaned without delving to the strength or otherwise of the matter, because that part is sub judice. Now, the two facts to be gleaned is that there is an order for arrest that has now been contested before a judge, for which it has been adjourned for ruling. EFCC is not supposed, after today, to be chasing Yahaya Bello anywhere. Even if he's walking in front of their head office, they are not supposed to arrest him, because now it has been contested before a court, and court has adjourned for ruling. Two, there is an application by Yahaya Bello that order of arrest should be stepped down because it has been overtaken by event since I have now been served. And on the next adjourned date, it is only when I don't show up that the court can be requested to issue a bench warrant. But now, having served me, the law requires for me to study the charges ahead of my arraignment. And so arresting me will amount to breaching on my right to prepare and come and take my plea. So, and that request, that order of arrest should be invalidated, has not been granted or refused because it has been adjourned for ruling. Where these two facts exist, the way we know it, we teach students in law school, is that party must maintain status quo pending the hearing of the various applications and objections, so that court will decide. If on that day, the court says, your request to set aside this order of arrest has now been overtaken by event because you are already before me, then fine. If the court says on that day you are not before me, so that means this order to arrest will have to be extended. Even if you throw away, there will naturally be a request that a bench warrant be issued since you have not appeared for your arrest. If the court set it aside, then you proceed to trial.
Meanwhile, the Commission has filed a notice of withdrawal to discontinue an appeal against an order of a Kogi High Court restraining it from arresting the immediate past governor of Kogi State, Yahaya Bello. In the notice filed on April 22, the EFCC said the withdrawal is predicated on the fact that events have overtaken the appeal. Joining us now on the morning show is Muiz Banire, a senior advocate of Nigeria and former Commissioner for Environment, Lagos State. Good morning and welcome to the morning show.
Good morning, my pleasure.
Dr. Banire, good to have you on the morning show. Quickly, two things. One, the EFCC versus Alhaji Yahaya Bello. There are many issues that are out there in the public domain. Should the EFCC have disobeyed a court order when there is a restraining order? Or did the EFCC act lawfully, in your view, in laying siege on Yahaya Bello's home in Abuja? Number two is the latest development, Okutakpa SAN discontinuing an appeal that they had filed against the judgment of the Kogi High Court, Kogi State High Court. Now, what is the material effect of that in relation to the case before the court of Justice Emeka Nwite at the Federal High Court in Abuja? Those two things to start with.
Well, in the first instance, let me categorically say that to the best of my knowledge, EFCC have not disobeyed any court order at all. Most of the people that have been peddling that information certainly have not read the judgment. I've had the privilege of reading the judgment, and if you read it, I'm sure probably, most likely you have read it yourself as a lawyer, you will see that the import of the judgment is to say, refrain from harassing him, from defaming him, and so on and so forth. But the judge himself in that judgment put a caveat there to say that, however, where the Federal High Court issues any order, that order should be obeyed. And secondly, he also gave a directive that if they have any allegation against Yahaya Bello, then such to be formally brought before the Federal High Court, which EFCC has done. So in the light of that, you will discover that there is consistency in the two judgments. Prima facie, if you see it, you would think that there is a contradiction, but if you have read the judgment and what has transpired at the Federal High Court, there is no inconsistency and no court order has been disobeyed thus far. That's number one. With regard to the notice of discontinuance, of course, that is just consequential because the appeal before the Court of Appeal was in respect of the ex parte order, the interim order made by the Kogi State High Court. Eventually, the court had given the final judgment, thereby rendering odious the initial ex parte order. So it has become meaningless and spent. The appeal is spent. It's been overtaken by the subsequent judgment. So if there will be any appeal at all, it will be against the substantive judgment rendered by the Kogi State High Court, not the ex parte again. And that's what has happened. And it has no impact, no nexus with the proceeding before Justice Nwite at all.
Thank you very much, Dr. Banire, and great to have you so you can just clarify a few things, especially yesterday we had Daniel Boala. I don't know if you've seen that interview, and we also had an opportunity to dissect the matter where the EFCC chairman had held a media parley and had almost as if explaining the side of the EFCC, breaking down the efforts of the EFCC to invite in former Governor Yahaya Bello and his resistance thus far. A number of people have seen that as being perhaps having an adverse impact on the case at hand because it's already, they're hoping to charge him to court and he's already being, as I would say, defending his own case before his own court. What do you make of that? Do you think that the EFCC perhaps ought to have stayed low in terms of providing information, not conducting a media trial in order to strengthen their case and not in any way adversely affect their case against former Governor Yahaya Bello?
Well, I'm sure that it's not the public that is going to determine the case ultimately. I'm sure from what I've seen, my own observation, the EFCC was drawn out by Yahaya Bello through the various statements credited to his own media team. And they felt that they need to respond to the public opinion on the issue. Because again, you will discover that what he has said, what they have said, that is the media team, is that there have been a disobedience of court order and so on. He was never invited and so on and so forth. But even in his own affidavit, if you have read the judgment of the court of Kogi in respect of the fundamental, you will discover he himself affirmed in the affidavit that actually he was invited, and he confirmed that he was invited, and all. Those were explanatory things that has nothing to do with the substance of the case before the Federal High Court. In fact, I observed that the chairman struggled as the lawyer throughout that media parley to avoid touching on the substance of the case before Justice Nwite. So to that extent, if it's something to do with the general effort and to respond to the public outcry, I'm not too sure that is harmful to the administration of justice, particularly in respect of the subject matter.
Okay. Dr. Banire, good to see you. I want you to react to what a lot of people are now saying against the EFCC, that the EFCC chief shouldn't have come out to grant that press conference, that he said many things that can be used against him, against the EFCC in the court of law that could destroy the case. Things like when he said that he granted Yahaya Bello privileges and the likes, and he was talking about the detail of the 720,000 and all of that, because there's been a lot of blowback to the EFCC. I want you to clarify all of that.
Well, my very strong view of it is that the courts are insulated from all those social media or media parley information. A judge is not meant to live by those pronouncements from the media parley at all. So if you look at it critically, that is the evidence before the court that ultimately will determine the fate of the defendant. It's not what was said outside there. If, for example, I say to you now that you stole 500 million naira, and I'm unable to provide any evidence before the court. Even if I said it 1 million times in the public space, it amounts to nothing. So I do not see it in any way hurting the case of either parties before the court. Like I said initially, what has happened is more or less a situation where you had to respond to public exposition as to the issue of the aggression by the EFCC. So I'm not sure they have stepped out of their bound by so doing at all.
Okay, Adedipe SAN, who is counsel to Alhaji Bello, approached the court, I think this week, asking that the bench warrant order be vacated. And there's been an adjournment, I think, till May 10. Now, a substituted service has been given to the lawyer to pass on to Alhaji Bello, which means it's now been properly served in this particular matter. What should we expect next? Both from the EFCC
what we expect is that
and from the court.
What I expect.
Yeah, please go ahead.
From the court, my expectation is that arrangement proper will take place at the next adjourned date. And now he has been served with the charges, including the proof of evidence, which I expect that his lawyers by now will have been studying alongside himself, so they'll be able to prepare their case and come before the court to either apply for bail. It's a bailable offense, and if the court is so disposed, bail is granted, and at the end of the day, he probably will regain temporarily his freedom to the determination of the matter. But on the part of the EFCC, if they are ready to prove their case, in some court, the matter will proceed that day, if they have their witnesses on ground. In some other court, the court will adjourn for a specific date for trial to commence. So that is the expectation.
But Justice Nwite still has to address the matter about the vacation of the bench warrant, which counsel requested for.
Well, my view of it is that if, for example, on the next adjourned day, Yahaya Bello turns up in court, then automatically the warrant of arrest becomes spent. So there will be no need, it becomes academic, there will be no need to even rule on that again. But if otherwise, that is where I partially disagree with Daniel that, look, a court order until set aside is alive, is extant, is living, and we must abide by it until set aside by a competent court. Otherwise, you still must abide by that order of court.
Right, let's go back to the claims made by the media office of Yahaya Bello, saying that he wasn't even invited in the first place by the EFCC, and they should make proof of the fact. And bearing in mind, during the media parley, it did seem like it was just a verbal, I don't know if a written invitation was made to Yahaya Bello. In the event that there was no written invitation, would they then have a case to say that there was no reason to have come to arrest him if the EFCC had not, in fact, invited him formally into their office for questioning?
Well, to the best of my knowledge, from what he himself said, that's why you need to go and read that judgment, or that particular judgment he obtained from the Kogi State High Court. He himself deposed to the affidavit to the effect that I was invited. He said that much there. So that is an admission of fact. So that is not in dispute. It's not a contest again that he was invited. He stated there, you may go and look at that particular affidavit that was deposed to in support of his claim for fundamental human rights. So that is not in dispute again.
Okay. So, I mean, there are many other matters that are emanating from all of this. I want you to talk about the drama with the arrest. If somebody, the EFCC wants, somebody to come and account for a case, why can't he just turn himself in? Why all of this legal drama? And these two courts of competent jurisdiction going at loggerheads with each other. I mean, I want you to talk around that drama and the judiciary itself by extension with what is happening as regards this case.
Well, the courts are not at loggerhead at all. In fact, the judge was very, very clear in his judgment to say, I have no power to restrain the EFCC from investigating Yahaya Bello. Very clear. He was consistent. In fact, he repeated that almost 3 times. Relying on the case of IGP against, I forgot that, Imba, that he said so consistently that I'm not in a position as a judge or as a court to restrain the FCC from investigating you as Yahaya Bello. My only business is that where there is infraction or likelihood of infraction of a family, that's why I will come in. But I will not say they should not do their job. That much the court have said. So there is no inconsistency. Like I said, the court are not at loggerhead. The court are on the same page on all the issues that I've said.
Who is trying to skew the narrative
Secondly,
now?
the drama itself.
Who is trying to... So are you saying the Yahaya Bello camp is trying to skew the narrative now by saying otherwise?
Well, I believe so. From all the judgment that I've read, the judgment of that court that is relying upon and what has transpired before the Federal High Court. As far as that's concerned, the media team of Yahaya Bello is the one. Maybe, let me just be courteous to say that they misconceive the import of the judgment out of courtesy. But beyond that...
Please go ahead. Please go ahead. Please go ahead. Please go ahead. You were going to say something.
Yes. On the other, yes, in respect of the drama that you alluded to, honestly, it's amazing to me too, because simple invitation, you have claimed in the fundamental human rights action that, look, these people are wishing me, they are being propelled by my political adversary, the allegations are business, frivolous, and all those things. So there is a platform for you now. There is an opportunity for you to clear the air to say, look, everything they are saying is all lies. Now, why are you resisting to go there just walking? I would have expected, in fact, it's not the first time. So many other ones, like former governor of Kwara walked in, Obiano walked in. In fact, I recall vividly, as a commissioner under the current president, the day we vacated office in 2007, we reported in EFCC voluntarily the next day. We did not even wait for them to come, just like Vacating also did. So this time around, even if you have refused to honor the invitation of EFCC, what of that of the court? This is an opportunity for you. You are presumed innocent of all the allegations. So walk in and show and prove to the court. In fact, I regard it that what is playing out is a very, very old and archaic template. There is an established template by his ex-wise colleagues, which probably he should have followed. And that would not have created this kind of drama that is going to go in now, because ultimately, whether he likes it or not, it will still appear in that court. So what is the big deal in going before the court? So for me, it's unnecessary, it's unwarranted.
Well, Dr. Banire, one of the things we have talked about on this table has been the manner of the EFCC's operation. Ola Olukoyede, the EFCC chairman himself, was saying during his press briefing that he sent 50 of his men, 50 EFCC officials, to go and arrest one man. When they got there, they met 30 policemen protecting a former governor. Now, what does this say about our system, about our law enforcement process? Now that we are having a justice sector reform conference, even right there in Abuja, where you are. What does it say? I mean, 80 officers in one operation from EFCC side and police side. Because of what? In terms of cost, in terms of the spectacle.
Well, I agree. Well, I think I agree with you. That is a fundamental issue that needs to be addressed. And you may wish to go back to history, particularly during the last administration. If you recall, we had a lot of confrontation during the Buhari administration that to the extent that you probably will want to repeat the situation then as that of being in a jungle. And I think that that's what most likely the commission must have foreseen, and where they eventually now saw, which became justified, that look, we will get there, some defendant will, if they don't have policemen, they don't have other security officials to protect them, to resist arrest, some will even hire thugs. So it has become a situation now that if you want to go there, you have to be well fortified. Otherwise, you risk the life of your officials. That probably accounted for what has transpired on the part of EFCC. On the part of Yahaya Bello, he probably also anticipated that when they are coming to call in their dozens. So he decided to fortify himself. And I'm glad that that issue is now being immediately addressed. You can see that I understand that all those security officials has been withdrawn. Some of them are even undergoing interdiction already, which is the proper thing to do. So by the time they start doing this, that won't happen next time. You see, there is a confusion among the security officials as to where their loyalty lies. At times, they tend to forget that the loyalty is to the federal government, Federal Republic of Nigeria, by way of the oath that is taken. They tend to shift it to the individual in which they are serving, which is a misplaced priority, a misplaced one, a misplaced loyalty. So this is part of what is to be addressed by the various organizations and the rule of law institutions. That look, you will recall during the Magu drama too, when the Department of State Security wrote a damning report against the nominee of President Buhari then. A lot of people, majority of Nigeria, including a lot of journalists, felt that was wrong. But I've always believed that where institutions are strong and institution works, you will discover that even the Department of State Security can write against even the president. That is because they are governed by their laws and not by individual, and their loyalty is to the Federal Republic of Nigeria and not otherwise. So to that extent, I believe that those next time such happens, one would have expected that even the attached security official to be the first line to effect the arrest based on the warrant issued by the court. That is my view of that.
Well, thank you very much, Dr. Muiz Banire SAN, for joining us on the morning show.